Okay, let's get right into this. Imagine you've just been wronged in a business deal. The other party completely breached your contract. Now, you might be thinking that a broken contract means an automatic, unlimited payday for you, right? Well, not exactly. In the real world of private law, achieving that perfect wholeness the court aims for isn't a straight line. Instead, you have to survive what is essentially a strict legal obstacle course just to get compensated. So today, in this explainer, we're going to walk through the realities of recovering damages, focusing entirely on the limitations that can restrict or even completely prevent your legal remedies. Here is the map for our obstacle course. We are going to tackle 6 specific hurdles a claimant absolutely must clear to win their case: foreseeability, mitigation, certainty, losing the power of avoidance, agreements limiting remedies, and finally, the election of remedies. All right, hurdle number 1, foreseeability of the loss, anticipating the consequences. The core idea here is that courts simply won't hold wrongdoers responsible for bizarre, completely unpredictable domino effects. What's kind of fascinating is the history behind this. It's actually rooted in a famous English case from way back in 1854, Hadley versus Baxendale. The rule was established to prevent a limitless chain of liability. Basically, if you breach a contract, you're only on the hook for consequences you could have reasonably anticipated at the exact moment the contract was signed. It creates this absolutely crucial boundary, so defendants aren't bankrupted by obscure, far-reaching events they had literally no way of predicting. This doctrine basically splits damages into 2 distinct buckets. On one side, we've got natural losses. These are things that happen in the ordinary course of business, like an employee losing their salary after being wrongfully terminated. Everyone expects that. But on the flip side, we have special damages. These come from totally unique circumstances. Going back to that foundational 1854 case, imagine a mill owner who loses a massive amount of profit because a carrier delayed delivering one single crucial repair part. The carrier's not automatically liable for all those lost profits unless they were explicitly warned during the making of the deal that the mill couldn't function without that specific shipment. Simply put, no explicit warning means no special damages. To put this into perspective, think about the fairness filter courts apply here. Imagine a messenger who charges a tiny 20 ZMW delivery fee. If they drop the ball and fail to deliver a package, and that failure somehow triggers a massive 1 million ZMW loss for the sender, well, a judge is highly unlikely to force that messenger to pay $1 million over a 20 ZMW fee. Not unless the messenger formally and explicitly agreed to take on that massive extraordinary risk up front. The penalty has to make sense for the value of the original agreement. Moving right along to hurdle number 2, mitigating your damages. Stopping the bleeding. So assuming you've cleared that foreseeability hurdle, you hit this snag. Even if you're the totally innocent victim of a breach, you can't just grab some popcorn, sit back, and watch your losses grow, just so you can sue for a bigger amount later. The law actually requires you to make a good faith attempt to minimize the damage. You have to take active, reasonable steps to find substitute arrangements. Find a new job, a new supplier, a different buyer. If you don't even try, the breaching party is legally entitled to deduct the amount of that avoidable loss from your final payout. But here's a really interesting question. How far do you actually have to go? Let's say you lose your highly specialized advertising sales job because of a contract breach. Do you have to go drive a taxi just to mitigate your losses? Nope. The law demands a reasonable effort, sure, but it doesn't force you into undue humiliation, massive personal risks, or accepting an alternative that's fundamentally different from your original deal. You don't have to drive the taxi. And honestly, courts are pretty forgiving if you're genuinely trying. Think about a film producer whose lead actor completely bails right before filming starts. The producer frantically scrambles and hires a much more expensive replacement just to save the shoot. Later on, someone points out, hey, a cheaper replacement was actually available. Will the court penalize the producer for that? No way. As long as it was a diligent, good faith attempt based on the chaotic information available at that moment, the court won't use perfect 20/20 hindsight to punish the innocent party. Which brings us to hurdle number 3, the certainty of damages, proving the numbers. This hurdle is all about the cold, hard numbers. You can only recover what you can concretely prove. And this is a massive roadblock for anyone trying to claim intangible losses, like lost business goodwill or future profits. The legal system literally despises speculation. If you march into court and say, I totally would have made $1 million if they hadn't breached, the judge's immediate response is going to be, okay, prove it with concrete evidence. Let's look at how this plays out in the real world. Take Alf. Alf is an entrepreneur with a brand new, totally unproven product. A factory breaches their manufacturing contract, and Alf's project tanks. Alf once lost profits. But sadly for Alf, he gets absolutely nothing for lost profits because he has no established track record. His claims are deemed legally speculative. He might only get his out-of-pocket warehouse rent back. Now compare that to an established business. If there's supplier breaches, they have the historical baseline, the market data, and the financial records to say exactly what their profit margin usually is. They've got the paper trail to clear the certainty hurdle easily. Next up is hurdle number 4, losing power of avoidance. Basically, use it or lose it. This hurdle deals with equitable remedies, specifically rescission, which is just unwinding a bad deal so it's like it never even happened. The key principle here is use it or lose it. Let's say you discover a huge flaw in your contract, like you were defrauded or there was a massive mutual mistake. You absolutely have the right to avoid the contract, but you have to act decisively. If you find out you were misled, but you keep happily accepting the benefits of the contract anyway, you are silently telling the law that you intend to stay bound by it. Do that, and your power to avoid the contract is permanently gone. There are 3 major traps you've got to watch out for here. First, intentional affirmation. Like we just said, that's discovering fraud but continuing to take the perks anyway. Second is latches. This is just a fancy equitable term for unreasonable delay. If you wait too long to speak up after discovering the flaw, the clock runs out. And third, restitution impossible. If the contract was for raw materials and you've already consumed them, or maybe perishable goods that spoiled, you can't put things back to their pre-contract state. You can't uneat the sandwich, right? So the right to rescind is lost, though you might still be able to sue for monetary damages.
All right, hurdle number 5, agreements limiting remedies, freedom of contract.
Now, this obstacle is wild because it's actually built by the parties themselves, way before a breach even happens. Under the principle of freedom of contract, you're allowed to build your own barricades. You can predetermine your liability, like setting a hard cap on payouts or restricting relief to just repair or replace. But, and this is a big but, for courts to actually enforce these self-made limitations, they have to meet strict criteria. They must be conspicuous, meaning clearly communicated, not buried in invisible fine print. They have to be mutually agreed upon, and crucially, they cannot be fundamentally unfair, or what the legal world calls unconscionable. If it passes those tests, the contract itself limits your remedy.
And finally, our last hurdle, number 6, the election of remedies, choosing your path. This doctrine basically forces the claimant to look at a fork in the road and make a permanent, irreversible choice. The legal system forbids double dipping. You absolutely cannot seek multiple forms of relief that contradict each other. You can't ask the court to enforce a contract in one breath, and then in the exact same breath ask them to pretend it never existed. You have to pick a lane. Let's walk through a practical example. Say you bought a piece of factory machinery, and it was completely misrepresented to you. You have 2 choices. Path 1. Affirm the contract. You keep the machine, keep paying maintenance, and just sue for the monetary difference in value. Path 2, disaffirm the contract entirely. Return the machinery, get your money back. But here's the catch. Once you start paying maintenance on that bad machine and using it on your factory floor for months, you've crossed the point of no return. You have officially elected to affirm the contract. You can't suddenly change your mind later and try to pivot to path 2. So what does this all mean for us? Well, we've seen that foreseeability, mitigation, certainty, and all these other doctrines create a massive filter. A broken contract simply does not guarantee a payout. So I'll leave you with this. Take a look at the contracts you're currently relying on. Are they truly solid assets that anticipate these hurdles? Or, if things go sideways tomorrow, are they just a legal obstacle course waiting to trip you up? Definitely something to chew on the next time you sign on the dotted line. Thanks for joining me on this explainer, and keep learning.